Hello and welcome. You're watching India Today. I'm Smita Sharma. Of course, there's history that's been made in the cricketing world, but let's focus to the breaking news that's just coming in at this point in time. The National Investigation Agency, the NIA court, has sentenced Indian Mujahideen operative Yasin Bhatkal to death. All 5 IM operatives have been given death by a special NIA court, including the Indian Mujahideen co-founder. Remember, he is, of course, a leader of the proscribed terror organization in Indian Mujahideen. He's around 33 years of age, and this is the organization that has been blamed for several, in fact, attacks in India as well. But now the NIA court, because the Hyderabad twin blasts case, which of course was being heard, the Hyderabad blasts that happened in 2013, an NIA court was all set to pronounce its statement. So that sentence has now come in by the NIA court, and it's the quantum of sentence, in fact, to the 6 accused in the Dilsukh Nagar twin blasts, which occurred on 21st of February 2013. 18 people lost their lives in these blasts. Indian Mujahideen co-founder Yasin Bhatkal, Ziaur Rahman alias Wakas, Asadullah Akhtar alias Haddi, Tehseen Akhtar and Ejaz Sheikh, as well as IM founder Riaz Bhatkal. The prime accused in the case, of course, has been absconding. They were convicted by the NIA court in the Cherlapalli Central Prison on 13th of December. Remember, this is the first time really that Indian Mujahideen, in fact the top brass, they have been convicted in a case in Indian court. The sentence had been posted for later, and charges were framed against the 6 accused, 5 of whom, excluding Riaz Bhatkal, were lodged in the Cherlapalli prison. Ashish Pandey is joining us live from outside the NIA court in Hyderabad. Ashish, take us first of all, what exactly has the court said? Any other observations that have been made?
Today only the quantum of punishment was discussed inside the court. Right now you can see behind me here in NIA officials and the government lawyer, they are briefing the media. Right now we can inform you and our viewer that yes, today the NIA special court, which is made inside this Cherlapalli Central Jail, he has pronounced the capital punishment to all those 5 convicts of Indian Mujahideen who got convicted on 13th of this month. Today, court clearly said that yes, the evidence produced by the NIA investigative team and the government lawyer, it was very much there, and they believed on the NIA argument, and based on that argument, based on even NIA has demanded, the lawyer of NIA has demanded capital punishment. The court pronounced capital punishment to all those 5 accused. If you talk about the accused, these accused are Yasin Bhatkal, the co-founder of Indian Mujahideen, Wakas, who is a Pakistani national, then Asadullah Akhtar, who is a native of Bihar, and apart from these 2 other persons, they have convicted all those 5 person, and now the court verdict is that they'll be getting the capital punishment. They'll hang till death. Smita.
Yes, so the 5 accused, of course, that you are mentioning who have been convicted in this case, including the Indian Mujahideen co-founder, they will be hanged to death, is what the NIA court has pronounced in Hyderabad in context of the Dilsukh Nagar blast that claimed 17 innocent lives in December of 2013. The members, of course, belong to Uttar Pradesh. Ziaur Rahman, a Pakistani national, as Ashish Pandey there was mentioning. Tehseen Akhtar from Bihar, Ejaz Sheikh from Maharashtra. Asadullah Akhtar, alias Haddi, is also another, in fact, cadre member. But, Ashish, as far as the family members of the dead are concerned, have you managed to speak to any of them? What was the initial reaction like in the court when the quantum of sentence was pronounced?
Of course, Smita, all those family members, particularly we get in touch with 2 particular family members. One where a daily wage laborer lost his son, only earning son, and he and other person who is also lost, who suffered serious injuries in this blast. Both are showing their satisfaction. They were earlier demanding the capital punishment. Now court has pronounced capital punishment. Definitely they are very happy. If we talk about this blast and the circumstances circumstances and the investigation of this blast, it took almost 2.5 years to NIA to bring the case to conclusion. Now case is got its final conclusion. Meanwhile, we spoke to the defense lawyer, the lawyers of all these 5 persons. They are saying that definitely they will move the higher court. That's their right. Now the special NIA court has pronounced the capital punishment. Now the defense lawyer, he is very much ready to move to higher court, to Hyderabad High Court. That's the separate stage of this whole Dilsukh Nagar blast case. But right now, the victims, the family of all those injured, they are showing their satisfaction, and it's a big and massive, I can say, massive judgment coming out from this special NIA court jail. This jail was made a few years back when during one particular hearing, Yasin and other 4 of his associates tried to throw some paper, some letter to media, and then the security concern was raised. Based on that security concern, the administration decided, the jail authority decided that they will make a special cell, a special court inside. NIA 2 agreed on this arrangement, and now this special court made inside Chellapalli Central Prison, they announced the capital punishment, the maximum punishment to all those 5 suspects. 22nd February 2013. At around 7:05 to 7:08 p.m. in the evening, the blast took place in crowded Dilsukh Nagar blast market. Twin blast took place, claiming 18 lives, and now this verdict definitely is a big announcement. It's a big message to all those who are involved in such kind of terror activity in our country, in India. Smita.
Ashish, stay on with me. I'm joined by Mr. Majid Memon, who is, of course, a senior criminal lawyer. He's a senior advocate. Mr. Memon, how do you look at the quantum of sentence that has been pronounced? Because obviously this will be challenged by the defense in higher courts too, but does it look like a watertight case at the moment to you?
Well, you see, if at all death penalty could be justified, it is the cases of this type, the act of terrorism, when found established beyond reasonable doubt, the certainty is that the quantum has to be extreme punishment. And the learned judge has precisely done that. I have my own anxiety that I hope that the evidence has been properly recorded, as also the conclusions are rationally drawn by the learned judge in a very professional manner, so that this conviction recorded by him and this sentence awarded by him would stand the scrutiny of 2 learned judges of the High Court, who are supposed to be, according to the procedure, confirming the sentence. Because this judgment, this conviction or sentence becomes executable only upon confirmation by the High Court. That is a procedure in law. And even such matters would go to Supreme Court. So I wish and hope that the learned judge must have done his duty well. He must have recorded the evidence in a proper manner, without any flaws, and must have based his reasoning to come to the conclusion that the offence has been established against the accused persons beyond reasonable doubt. And thereafter, of course, as far as quantum is concerned, I don't think there should be any difficulty in upholding the extreme sentence in cases of this nature.
So, of course, you started your answer by the very premise saying that this looks like a case, this is a case where death penalty can be, of course, exercised, where it's beyond reasonable doubt. But we also saw the case of Ajmal Kasab in the Mumbai attacks case, 4 years of trial, all process of law followed. Finally, he was hanged to death. This is the first time that Indian Mujahideen cadre and top brass is really getting convicted in a case. Do you think this will send out a strong message?
No, remember, there are 2 distinct things. One is establishing a case beyond reasonable doubt is an unescapable duty of the prosecution. Unless that is done, the question of holding somebody guilty doesn't arise, not to talk of awarding of sentence. Because awarding of sentence is another department. You see, once a person has been found guilty, and for finding a person guilty, the learned judge must record that there are reasonable grounds to believe that there are no reasonable grounds to believe that the accuser has not committed the offence. And therefore, beyond reasonable doubt, when an offence is established, it is only then that the guilt is recorded. And it is only if, in cases of terror, if guilt is recorded upon belief that there are beyond reasonable doubt that this person in the dock has committed the crime, then in that event, as far as quantum of sentence is concerned, in a case of terror, certainly there will be no difficulty in justifying the award of extreme penalty.
Sir, just one last question before I let you go. You of course have been following a lot of these cases, the terror-related cases yourself. How difficult was it, do you think, as a case? Because given the fact that the founder, Yasin Bhatkal, has been at large, he has been absconding, would you say that this was a very difficult case for the agency itself?
Well, certainly for the prosecution, it is an uphill task. You see, first, after you register the crime and you arrest an accused person, you have to collect evidence, enough evidence which should be inspiring confidence of the trial court. And then after collecting evidence in a professional way, you have to place that evidence by examining witnesses in the trial court. And it is only upon successful collection of evidence and reliance of evidence before the court, placing of evidence before the court, that you may succeed in establishing a case beyond reasonable doubt, which probably in this case the prosecution has successfully done.
Many thanks, Mr. Majid Memon, senior advocate, joining us on India Today on this piece of breaking news that we have been broadcasting for the benefit of the viewers joining us at this point in time. Remember, this is the big breaking news that's coming in from Hyderabad. The special NIA court that has just pronounced its quantum of punishment to the Indian Mujahideen co-founder Yasin Bhatkal, who also goes by the alias of Muhammad Ahmed Siddi Bappa, and 4 other cadre members. Also, Yasin Bhatkal, remember, the founder, has been absconding, he's been at large. Death sentence is what the NIA court has handed over to the 5 of them in terms of course, for the February 2013 Dilsukh Nagar blasts that claimed at least 16 lives. Okay, let me in fact try and get in a word from Mr. Arun Singh, who's Colonel Singh, who's also a strategic affairs expert. Sir, your first reaction to the quantum of punishment that has been pronounced, the death sentence to the IM co-founder and the cadre?
No, I was expecting as much. I had been following the trajectory of this case, and I was expecting it as much because remember these Bhatkal brothers and their accomplices. They were the architects of terror in India. They were the ones, who were identifying new areas, setting up new bases, and taking orders for one of the Bhatkal brothers, from Pakistan. And so therefore they were very much, very much. They had a hand in gloves with all the terror activities that were carried, most of the terror activities that were carried out here. So they in fact, the Bhatkal brothers are responsible for establishing new bases in areas like Bihar. And you must have noticed that after their arrest, there was a major dip as far as the
okay, Mr. Singh, I would have to interrupt you at this point in time. I need to in fact shift to Hyderabad, where my colleague Ashish actually has the public prosecutor with him. Ashish, over to you.
Sir, tell me about what exactly court said, and I believe it's a rare of the rarest case, and that's why this kind of judgment came.
Yeah, this court has been considered as the rarest of rare case, and the court has decided, court has given this verdict. This is really a great victory for the efforts taken by us, and the court has convicted all the accused persons. The court has sentenced all the accused.
Any particular observation made during this hearing, sir?
Like
court said anything, or the convict said anything after hearing the verdict?
Yeah, an opportunity has been given to the accused persons also to take something upon their sentences, but they have just furnished a simple application, and that has been also considered by the court. After considering all these things only, the court has awarded this death sentence.
What was the reaction, sir, of all those convicts, sir, all those 5 convicts, after hearing the verdict, sir?
No reaction. They have not given any reaction. They don't have any rumors, and they don't have any disappointment on their faces.
Any particular argument you made in front of the honorable court, sir?
Yeah, because see, lot of victims have been, lots of casualties are there, lots of victims are there. So they have sustained lots of injuries. Some unborn child was also died. These incidents have occurred now. So after considering the gravity of these offences, the court has convicted them.
Thank you, sir.
Ashish, can you just ask
clearly,
one quick question?
Like the public
Ashish, can you ask him just one quick question?
This particular case.
Ashish, if you could please ask if the
yes,
public
Smita.
prosecutor is
Yeah,
still
tell
there
me,
with
tell
you,
me,
would you
tell me.
ask him, does he see it as a challenge? Because obviously the case will be challenged in higher courts. Does the prosecution believe that they have a watertight case, that the quantum of punishment will actually be maintained by the higher courts as well?
Sir, basically our anchor is asking whether you felt like it's a big challenge in front of you and you made this case a complete watertight, and how you prepared all the trials and finally the conviction.
See, more than 150 witnesses we have examined during the course of trial, and it was really a big challenge to us, and there was a lot of security problem also. So however, without considering those aspects, we take up this challenge and we conquered it.
And my final question, sir. So the entire judgment, you can tell me like the entire judgment copy, how voluminous this judgment copy is, and now of course the defense will go to higher court. You are prepared to face them, challenge them in the higher court also, sir?
We were prepared, we are prepared, and we will be definitely prepared. No problem.
Like Smita, clearly almost over 700 witnesses, and the NIA made the case very waterproof, and finally this kind of conviction. This is the rare of the rarest case, and finally the NIA, the government of India, they got the capital punishment for all those 5 terror convicts who carried out twin blasts.
Right, Ashish, stay with me.
Of course, it's a big success for NIA.
Ashish, stay with us. I'll come back to you. Of course, we are talking about the Dilsukh Nagar blasts in February of 2013. Remember, the first bomb went off at Anand Tiffins. This was located outside the Konark Theatre at around 2 minutes past 7. And the second bomb went off at around 6 minutes past 7 between Venkatadri Theatre and Dilsukh Nagar bus stand, claiming at least 17 lives and injuring more than 130 people there. Colonel Arasan Singh also continues to be with us, strategic affairs expert. So you just heard, in fact, Ashish was talking to the public prosecutor in Hyderabad, saying that more than 150 witnesses were examined. This was obviously a challenging case. What do you think would be the biggest challenge for the prosecution, going into the higher court?
No, I think as far as the higher courts are concerned, there only the procedures can be challenged. I mean, findings must have been found out, after meticulous consideration and care. So I have absolutely no doubt that even if they approach the higher court, there would be any, different outcome. But the fact of the matter is, yes, there is a watertight case. There must have been a watertight case as far as the Kushanagar blasts are concerned. But also, importantly, do not ignore the fact that these fellows were also the architects. If I may say so, at the cost of a reputation, that they are the architects of this entire terror network.
Right.
And particularly the Bhatkal brothers, they have been. They have vitiated the entire area in that Bhatkal region and the state of Karnataka.
Right.
Not only that, they have spread the tentacles to the rest of the country, places as far away as Bihar. So
right.
to that extent, I mean, their act is not only heinous, they are very, very. I mean, very, very.
Right, sir. Many thanks for joining us with your perspective, and also Ashish, of course, we will continue to cut back to Ashish in Hyderabad. He was just speaking to the public, in fact, prosecutor. So this is the big development. Remember, Yasin Bhatkal, the co-founder of Indian Mujahideen, along with 4 other cadre members, one of them a Pakistani national, 3 others from Maharashtra, Bihar and Uttar Pradesh. The sentence has been pronounced, in fact, for the Dilsukh Nagar blasts. And the NIA court has said that they will be hanged to death. We continue to get you all the updates on this story.